Good afternoon, everyone. A very warm welcome to today's panel discussion on a highly relevant and pressing topic. Is the Indian legal system ready for wartime law? Firstly, my sincere thanks to our distinguished panelists for joining us today and to our audience for your presence and participation. I would like to begin today's discussion by inviting us to reflect on how our constitutional framework addresses modern threats. When the Indian Constitution was drafted, the idea of war and external aggression was sharpened by the context of conventional state-to-state conflict. But today we have very different challenges, from the cyber attacks to hybrid warfare and disinformation campaign. So, Moksha, I would like to open today's discussion with this thought that Article 352 of Indian Constitution outlines the framework for the national emergency. Given India's past experiences, particularly 1975 emergency, what specific judicial reforms are still needed?
To address that, first I think we should address what is a national emergency and what can actually come under the phrase called national emergency. Now, a scenario where there is an external threat to the entire nation, and we presume that any decision to protect the country as a whole does not call for a detailed protocol approach of information flow. This is the point where national emergency declaration is respect to be made in any country. Procedurally, whenever a policy decision has to be taken, let's say there is a line of control threat or you have a strain in line of control, what is supposed to be done, how fast it can be done, whose approval is required is what has to be debated in a national emergency situation. Do we have a line of control threat as of now at this point of time for this country? Now, if we take any intelligence report, it will always say moderately no. What do we exactly mean by moderately no is there is no requirement of national emergency. When it says negative, then there is a need for national emergency because military will prevail over civilian rights. Protocol is discarded, military decisions are applauded because they are presumed to be in the best of interest of the country. Now in 1975 and 77 scenario was different where this particular step was taken, and after that in 1977 adoption was done, and there was a need for an extensive debate on national emergency to be called because that will derail two articles. It will by and large make Article 20 and 21, personal life and liberty of the people, not to be seen, freedom of press, not to be considered. When these two are there, classically we are seeing democracy to be zero. Current state, and if we actually see all other parts of the world, Bharat, that is India, is not in such position. But in case that position comes, what should be the steps that are to be taken has to be first addressed by something called what should be the amendments which we should do in our Disaster Protection Act. Because when there is a national emergency, the first thing that is going to hit is this act. What are the, we have heard news, there's a Gaza-Israel war going on. There was a Lebanon fight. There was an Israel-Iran attack. Now in all these cases, when you see the news, the concept which we hear is there were facilities given, there was support being given, there were medical facilities being given, but it was not reaching to actual victims or sufferers. A Disaster Management Act or a National Disaster Management Act would address this particular issue. The system in which support are to be channelized and then passed to the respective locations. This has to be amended and improved. This is the first need of the hour. Before we actually talk about national emergency, step one is your Disaster Management Act to be observed, find what are the areas, how do we protect freedom of speech, how do we protect freedom of the press, and how do you protect the life and liberty of the individual civilians in the country. Now once this is done, then we talk about whether we should implement 352 or not. Unless we do that, This doesn't make any sense. There's a second leg to it. The second leg is cyber attack. War is not outside in any country today. War is inside every country, which is otherwise your cyber war. There are cyber attacks on every government side of every country from other countries. We all have heard or seen in movies secret agents, embassies. There are two different things. Embassy actually talks officially about that country in a different country. Secret agents try to have information which is adverse to their country. They try to communicate to the country, though the country is protected. There are rules which are levied in treaties as to how do we deal with such situations. So when we talk about 352, a national emergency, we should actually also address the issues which are with respect to defects in the treaties which we have signed with various countries. This is what our EAM Minister Jaishankar ji is actually working upon. There are a lot of treaties that are revised, there are a lot of treaties that are amended in a recent 4 months. Some because they are not of security importance, they are not published. Some which are publicly required, they are published in the domain. So these are the things which I wanted to elaborate on.
Thank you, sir. So my next question is to Mr. Saurabh Sharma, sir. Sir, during wartime, how should the Indian judiciary balance national security with individual rights? And what role can it play in protecting fundamental rights of the citizens?
Well, that's a very interesting question, Mr. Rishi. But I'm very thankful to my brother, Mr. Moksha. He has done most of the job. My job is here rather, because he has laid down the basic foundation of what is to fall in this panel. As far as the role of the judiciary is concerned, as is evident and the history has proven it time and again, that judiciary's role comes only after the disaster has happened. They can only dig out the grave and see what was to be done and what is not to be done and what should have been done and what should be done. At the time when the operations are being successfully carried out, at that time judiciary doesn't have any role, because the sentiments of the public as well as the judiciary, they are also human after all, are with the army. They are with the forces. They cannot be harping on the human rights and Article 21 and blah, 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 because it is all to be done. But during the operations as well, like there was a case of a professor of a university who had wrongly or rightly, I would not like to judge that, comment on Ms. Qureshi, who was making the brief to the public about the Operation Sindoor. So there the judiciary intervened. They they made it a point that the fundamental right of that professor should not go violated. So that is the where the judiciary can intervene.
Thank you, sir. Sir, my next question is for both of you. That is, as we saw post-Operation Sindoor, India, which is using the water as a strategic tool in water rises as an ethical concern, which is an ethical concern for both. So how does the Indian law view this, especially with civilians depending on the shared rivers between Pakistan and India?
Rule of nature says man cannot have control on three things: air, water, and land. Rule of civilization says control on land is a civil right, which is seen in the form of registered documents. Control on air is a territorial right under National Green Tribunal. And control on water is again an ESG driven right for the judiciary. Now, having said that, when a particular natural resource crosses borders of two countries, it has to form part of the treaty which is between these two countries as to how a shared resource, which is natural in nature, can be used. Before I address the Indus Water River Treaty, I would also try to elaborate on the point that Himalayas are no one's land. That part of the world which has the great peaks of mountains and glaciers technically was no one's land. But all in the blues, China, in their mainland China to the expanded China, they have said this is part of China. Today, that is coming as a part of treaty because, surprisingly, China today says we have borders with India. There are thousands of discussions that are happening across both the governments, and the external affairs ministers are debating at length as to how, what and why, which resources, which military can be deployed, where they should stand, where they should not stand. Now when it comes to Indus Valley Treaty, it was very specifically said that these natural waters are on a brotherly peacemaking joint understanding of both the countries. Water was released. That was the old treaty. Now when Operation Sindoor happened, it did not happen because it was a sensitive issue, and did not happen because it was a dramatic issue. It happened because rights of the individual were not destroyed, they were crucified. So there were two options. One is you either cry on the crucifixion. Two, you get justice from the crucifixion. So the government preferred the second one. Now, instead of solving the issue, when there was a debate and a question that was raised, so we took a strong measure that treaty which says when there were joint relations stands cancelled, we stop waters. What was the expected behavior in the best of interest of a country? You negotiate. What was the observed behavior? They started debating and giving false allegations. Now this went to a altogether different concept. What I basically wanted to present here is, any natural resource between any two countries always exists to be shared only when there are peaceful brotherly relations. We don't see when let's imagine a scenario where an Israel person did some business with someone who was in Gaza. The Gaza person defaults, and now Israel qualifies Gaza to be an enemy country. Can we recover the funds? Constitutions across the world of every country says you cannot do business with any enemy country. If there are any balance pending issues, all issues are gone. They are enemy countries, so you can't exercise anything out of it. Now this is where treaties are. Now when the relationship is not strained, the relationship has become a warlike situation. Unless the warlike situation gets submissized, closed, or some negotiation happens, further treaty is supposed to be made. We need such treaties, and India has, to my knowledge, only in direct access. Just for the point of tax, with every country they have about 750 treaties. With respect to natural resources, each natural resource has a separate treaty with the concerned country. So every time when a situation like Operation Sindoor comes, the first thing which the Ministry of External Affairs does is to check what treaties were there with that respective country. Explore, put them on table, make a strategy which will help the strained relations brought back. This is what exactly happened. And Indus Valley, the whole episode, I need not reproduce again, but then the sense of it is we left water, we jetted it, again holded it, again we casually left it. This was only to see that our country is protected. At the end of the day, every government's responsibility lies to the citizens of the country who are in that place. Not the national, the citizens. That's what I intend to put from my side. Brother.
Well, that answers the question in the most apt manner. Otherwise, saying in economics, there is a phrase which means all other factors remaining the same. Just as my brother said, if all the other factors are remaining the same, the treaty will go into place. If the factors change, the attitude of the country towards that treaty is bound to change. What else do we do? Yeah.
Moksha, in your opinion, is India's current legal system strong enough to handle major cyber attacks that may amount to act of war?
It's a question which I think every country has answers.
More technical than legal, I guess.
Why I would put it like this. Cyber attack is factual. Law talks about rights, protection of rights. Having said that, as my brother have rightly answered for the previous question, judiciary, law enforcement comes only when event has happened and it comes to our knowledge that event has happened. Why did I say it comes to our knowledge? There was a cyber fraud which has happened in your bank account. Fortunately or unfortunately, your phone has gone in out of coverage area. You were not aware that a 5 lakh of debit or a 50 lakh of debit happened in your account. Now banks have one beautiful concept. They say, I discharge my fiduciary capacity from making a call to the client. So they call. Now since mobile is already in out of coverage area, call is also not connected. After 2 days, because you have done some repair to that particular phone, it catches the tower again. Now you receive a message that your 50 lakhs got debited. I don't say you, here you means some imaginary person. I'm not accessing your bank accounts. Now this is the time where you actually got the information. And this is where you have the attack. Now the judiciary plays, enforcement agency plays. You file a complaint, try to get the money returned, so on and so forth. All that exercise happens. The question that was asked is the legal system robust? It's not the legal system that has to be robust, it's the technical system that has to be robust. Because the legal system is always post-mortem exercise. First we have to establish our rights or our properties are infringed or we have incurred a loss, then you build the case, then you actually go to the court. It takes its own judicial time to actually solve. I said judicial time, which differs from case to case, category to category. No law is proactive. Law is a point of laying a discipline system. So if we say, are we ready for cyber attacks? That I think Ministry of Information Technology has to answer it. It's not Ministry of Law. Ministry of Law to extent can say, okay, this can be categorized as this type of cyber attacks. That's the reason in Information Technology Act, you see concept called cyber crime, which is further divided into bank frauds, you have a list of items. Because the first thing which any law does is define the problem. Then they define the pleadings. Then they define the procedure which is to be followed to get to a final conclusion. With respect to this, our Information Technology Act is robust. With respect to the concept of cyber stalking and other aspects, our BNS is competent. And the procedure at which you trial the case, BNS is also competent and complete. But can we stop a cyber attack with all this? Answer is no. Because cyber attack is not a part of legal system. It's a part of security system which has to be addressed by a different department. Law-wise, yes, we are robust, we are complete. And the beauty of law is, we always say, jurisprudence is evolving. And this phrase, jurisprudence is evolving, will be said in the same spirit by my great-grandson also. It will not change.
Yes, sir. Thank you, sir. So, Saurabh, sir, to you, do we have enough legal systems in place to ensure smooth coordination between the military and civil authorities during wartime?
Well, there is the National Disaster Management Act, but the problem is that the common parlance among the public as well as the government authorities is that whenever there is a military operation, the civil authorities, they lose their job. They have nothing to do. It's all taken by the military operations. Even as far as the cyber attacks you just mentioned, every one of us had received the WhatsApp messages saying that such and such link will be circulated and do not press on it because all your money will go and it is done by Pakistan. What authorities were there to control that? None of them. So there is no coordination actually. And as far as the cyber crime, I'm digressing from the question and coming to the earlier question more or less. But cyber crimes in India are not controlled by the authorities till date. There are so many cases where there are parking accounts in other cities where the money is being sent through cyber crimes and the offenders are not being caught robustly. What to talk of international cyber attacks? So obviously there is no coordination. Only the National Disaster Management Act, but as my brother also said, law is still evolving. We have to find out more provisions. We have to make more legislations to make that effect. It will take time.
Just to add one point there. When it is a national disaster, first thing that is removed in the country is communication. The first implementation to see that military operations run without any problem, the frequency which is used by the military operations at a radio level for communication is changed. Multiple frequencies are used. This is the technical aspect which I am saying. Multiple frequencies are used for communication at various levels. Your internet and all other facilities of the country will be removed. This is what we exactly mean by emergency. When a war comes, this is what is going to happen. So what maximum we can do is shoot, store. Whenever we get internet, we can upload. But we have the luxury of shooting and storing. That's it.
Very well, sir. So as a final question, considering all the points discussed, would you say that the Indian legal system is ready for the wartime law? Or are there any other significant hurdles that still need to be addressed?
We have seen so many wars, my friend. No other country can be more ready than India. All right. And there is a need for a law to be enforced. And as the law has to evolve, it will do over a period of time. But it will take time. And that will be done for sure.
See, there is an external war and internal war in every country. Every country now has, by and large, some law or the other in place for the external laws. For the internal laws, we are still trying to figure out as to what, how, and when. There is a proposal with the Ministry of Law which talks about how cyber-driven wars or cyber attacks which can be considered as cyber wars are to be quantified. It is still at a white paper stage. There is a detailed deliberation going on as to what comes in it, how it is to be identified, how do you identify the accused in it, and how do you actually do a prosecution for them. So once that is in place and the white paper gets into the form of a draft bill, then we will see it across and we can see the act to come out. But as of now, there is no specific law which addresses on this particular issue.
Thank you, sir. Now I would like to open the floor for the audience. Any questions?
Sir, yesterday one judge in Hyderabad has given lifelong sentence to a group of people who had conducted digital arrest of an executive and confined him to his room for about 7 days. Now the basic question which Rajendra Rishi put to you was whether the law is competent enough to safeguard, such people. My submission is that if you give such deterrent punishments and make a provision for such punishments, probably the cyber crime will go down.
So we have an entity called National Human Rights Commission. And fortunately or unfortunately, I see people in that system try to approach without understanding the spirit. Because when there is a life sentence given, or per se a capital punishment given, today, if at all a capital punishment has to be given in India, there is a phrase. That phrase is, this must be a rarest of rare crime to be given a capital punishment. Now, that is a very difficult question to classify. How do you match this phrase? Now, if we really give capital punishments to such type of digital arrests, when it is proved, you don't do anything much, put this fellow also to digital arrest. Or I remember that there was a movie in which I see the way the person was taken in. He says you give him food, you give him water, you give him whatever he wants. Make sure that he will not sleep. This is rarest of the rare punishment. If such type of things are given, and our National Human Rights Commission appreciates it, then I think execution becomes the real punishment for the person to not do such crime, and it becomes a lesson for others not to do. We see it in Crime Patrol, there is a phrase, Saba Kek Ko Seek Hum Sabko. That will be a reality. But what is happening here is, in India we don't actually give that seriousness in giving a judgment. A judgment is given at a lower trial court, immediately there is a 30 days of appeal time. Within that appeal time a bail is granted, and the person, though convicted, comes out of the court. Why I said all this is, judgment per se in itself is not the end of it. Judgment with execution and a protected execution is something which has to be in place. To add further, if there is a conviction on such parameters, there should also be a provision in law that no further parole or furlong will be allowed. If that is done, then we can say it as a remarkable judgment that is given. As of now, that was a good judgment which we have heard and seen till now, but then there are better judgments are expected from it.
So my question is that if we get into a situation of national disaster that we were talking about, what happens to the international treaties that we have? Like we have some impositions based on United Nations and other big judiciaries that we have to enforce, maybe human rights and other things. What happens to those treaties or those laws that are applicable to India as well? If we go into a war, let's say for Pakistan or any nation, what happens to them?
We had already given an answer to that while discussing the water treaty. It depends on the other factors, as I said. If other factors are remaining the same, in a war-like situation, those treaties go for a toss. International law is a gentleman's law. You cannot enforce it by force. Correct. It is a gentleman's law. If a country is going to attack on India, are we supposed to honor those laws and provide them water, food and whatnot? Or fight with them and cut off their supplies? So those UN conventions and treaties are gentlemen's law. We abide by them only when other factors are neutral, not in warlike situations.
Okay, and what happens?
I'll add to what my brother has said. Let me give you in a visualizable zone. When Israel struck Gaza, how many countries wanted to do business with Gaza? That answers your question. How many countries wanted to do business with Israel is not the question. National emergency was not declared in Israel. When there was a strike, national emergency was declared in Gaza. Now in Gaza, it's all over. No one wants to do business till things stabilize. This is the answer for your first part of the question. The second part is when I'm fighting with another person, then what my brother has already answered is correct. Because fight is on. As long as fight is on, sab band.
So the laws within India, they remain the same? If let's say a cyber attack happens in India from Indian entities or from external entities, they would remain the same. The breach conditions and the penalties for them, they would remain the same?
Cyber attack is a different concept. War attack is a different concept. If it's a cyber attack, then that cyber attack will be addressed under the cyber crime. If I know the accused, I will follow the law, punish the accused. If the accused is unknown, we'll try to find. We have resources to find.
Okay.
Any more questions? Thank you to our esteemed panelists for sharing such thoughtful perspectives and to our audience for your active participation and insightful questions. Today, we have covered some critical, crucial issues from constitutional provisions and judicial oversight to the challenges of modern warfare and the need for meaningful legal reforms. What's clear is that the real preparedness isn't just about having laws on paper. It takes coordination, accountability, and the willingness to adapt to the evolving threats. Thank you once again. Thank you all.